what's your most, whether it has to do with instruction, politics, or whatever, what's your most controversial opinion?
Well, it would be on what to say if you have been involved in a shooting.
Interesting. Tell us what's your opinion on that, and then why is it controversial?
The middle of the bell curve. The far ends of the bell curve. On one hand, you might have somebody. I've actually seen this on the internet. I'll answer the police anything they want. I've got nothing to hide. I did the right thing. And that's right up there with the Titanic is unsinkable, the mortgage is assumable. You've just dealt with one of the most traumatic things in your life, and you're not going to be in the ideal circumstance to remember everything exactly and minutiae in sequence. On the other end is the much more common advice, say nothing. And this advice comes from defense attorneys, most of whose clients are guilty. Talk to anyone in the defense bar. A high 90th percentile of those who are criminally charged, because the system usually does work, are either guilty as charged or guilty of a lesser included offense. Overcharging is common because 90-some% of these cases are resolved in plea bargains. And by definition, in any bargain, one side starts low, one side starts high, and they meet somewhere in the middle. To start high, you have to overcharge. It means they don't have a whole lot of experience defending the genuine innocent person who genuinely did the right thing. And if 99% of the people you deal with every day are in situation A and you tell them how to deal with situation A, that becomes your automatic default. The attorney, you haven't done anything yet, you're just asking him, what if? Says, never talk to the police. Well, that's wonderful advice for criminals. What the hell can they say that's not going to get them, dug deeper, except offering up another criminal in trade for going easy on them, which is a deal that is much better brokered by your attorney who knows the prosecutor and does this all the time. Your problem with the innocent citizen who has done the right thing, they've acted in self-defense and harmed someone, when they're asked what happened and they say, I'm not telling you anything, I want an attorney. That's what they expect from every guilty SOB that they arrest. So it creates a false positive. You're presenting as the criminal. For most of these guys, most of the officers, except for officer-involved shootings, every shooting they've responded to, whoever was laying in the puddle of blood was the innocent victim, and whoever had the smoking gun was the perpetrator. Well, you've turned the tables. You've reversed the roles on the predator. He's laying here in a puddle of blood. You're the one with the smoking gun. What's the first impression? And then it gets worse. Every genuine victim he ever talked to, when he said, lady, buddy, what happened? Said, this SOB did this horrible thing. I want him arrested. I'll testify against him in court. And every guilty suspect he ever arrested says, buddy, we're willing to hear your side of it. I ain't telling you nothing until I talk to my mouthpiece. Well, the bad guy's dying words in front of the cop. She shot me for nothing. Ma'am, what happened? I'm not telling you anything until I talk to my attorney. What do you expect? And talk to anybody who's ever been a cop. It's a whole lot easier to not get arrested than it is to get unarrested after the fact. And basically then it gets worse. Now, if you study a whole lot of these things, we're seeing more and more multiple offender attacks. Those of you listening to this, I'm sure you've seen John Corria's videos where acts of self-protection. Mm-hmm. He takes a video of an actual shooting from a security cam and dissects it and applies 20/20 hindsight and tactical lessons. Mm-hmm. Do you notice how many times 3 guys attack, one of them gets shot, and the other 2 run like bunnies? Mm-hmm. Well, you said nothing, and you were the one who pulled the trigger. You're now going to try to go into court and convince the jury that you were the good guy or gal with a gun. And the jurors are going to figure out, no, the other side won't be able to bring this up because it would violate your right to silence and might cause a mistrial. But the jury isn't stupid. The jury's going to figure it out. We've heard no testimony that she said, we know now there were 2 other bad guys. Her lawyer said at the beginning she was the good gal with the gun. There's no testimony that she told the police there were 2 other suspects. No testimony that she described them. No testimony that she said which way they ran. She knew these 3 people were so deadly dangerous she had to kill one of them. 2 more of just the same kind of ilk was out there running around threatening us and our families and our children, and she didn't tell the cops, and they want us to believe good person with a gun? Think about that. Think about that. The affirmative defense, in which you stipulate that you shot him but you maintain you were correct in doing so, in many ways is literally 180 degrees reversed from the typical defense strategy for the typical guilty client. Why do they generally not put the guilty client on the stand? Because there's nothing he could say that wouldn't inculpate him deeper, or he lies. Now there's a felony perjury charge that can be added, and it's presumed the attorney knew what you always assume the attorney knows what his client's going to say when he goes on the stand. It opens that attorney to a charge of subornation of perjury, which where I come from is a felony in and of itself, and would cost them a license to practice law. So of course I never put my clients on the stand. Well, in your case, it's not a whodunit anymore. We've stipulated she did it. She shot the intended rapist. The question is, why did she shoot him? Who can truly answer that except the defendant themselves? So some things turn around 100%. And on the issue of what to say at the scene, I take a middle ground. And the middle ground is called has become known as the brief statement. I give a 5-point checklist. And it's not words to memorize. Not this, I was in fear for my life. Okay, it might have worked 25 years ago. Today, if you shoot somebody and say to a cop, I was in fear for my life, oh, wow. And I bet somewhere in their wallet they've got the lawyer's card that says on the back, I am a client of J. Walter Shyster, okay? And the eyes are going to glaze over, and it's not going to go well. But 5 things that need to be established. First, what I call the active dynamic, what this guy did that made you shoot him. This man tried to drag my child into the back of that van, and he had a knife in his hand, whatever it was. Second, indicate cooperation. Okay, I'll sign a statement. I'll testify against him in court. Brief digression, they'll say, fine, here's a piece of paper. Sign the statement later. Yeah. Point out the evidence. A shooting scene is chaotic. Everybody is trampling it like the elephants returning to the Valley of the Lost Ivory in a Tarzan movie. Spent brass gets lost, gets moved, gets displaced by running feet and ambulance gurneys. And it creates the illusion that you fired from here instead of from there. The knife he attacked you with, somebody picks up and runs off with. Okay, point out the evidence before it disappears or gets moved. Fourth, point out the evidence. People don't want to get involved, particularly strangers from out of town who don't want to, oh my God, I don't want to have to fly back to San Diego for this thing. Wait a minute, that guy's got gang colors. Holy crap, she shot a gangbanger. If I testify for her, the gang will be after me. I'm out of here. Point them out now before they disappear and the testimony that would have exonerated you disappears with them. Fifth, at that point, invoke your right to silence. Do not say, I'm taking the fifth. And forgive me for not being able to keep a straight face, but for most people, taking the fifth means I decline to answer on the grounds that my answer may tend to incriminate me. Okay, you've just admitted you're guilty. Mm-hmm. Okay, I'm invoking my right to silence, and I'm invoking my right to an attorney. And the Supreme Court has said now you have to specifically say that. Not, gee, I think I ought to call my lawyer, but I'm invoking my right to an attorney. If you have joined ACLDN or whoever, make the call. But what I recommend to people is if you're not a lone wolf, have someone who is what psychologists call a trusted other, someone that the first person you'd call in an emergency, somebody who's likely to be home and in one place. Tell them that you've been arrested, you need an attorney, tell them call ACLDN. It would be an awfully good idea if your trusted other had those phone numbers, by the way. So point out the active dynamic, indicate cooperation, point out witnesses, point out evidence. The officers, You'll have my full cooperation. After I've spoken with counsel, I'm invoking my rights to counsel now. Not that script. Never read from a script, but those 5 points. So I've seen a whole lot of people on the internet because we live in a time when people don't want to read anything longer than a phone tweet. I heard Ayoob says, spill your guts to the cops. And that's not what I suggest. Now, from the beginning, you've established. From the beginning, you'll find in shooting trials, generally the first fact witnesses to testify are the dispatcher who received the 911 call, which they'll play with the names and addresses redacted usually. Then the responding officers and the responding medical personnel. They hear this is going to be the beginning of trial because the accusing side goes first. They have to lay a predicate. Someone was hurt, someone was killed, there was an investigation that led to this party. From the beginning, they've heard your side of the story. It will have been another thing that differs with typical defense lawyer practice. I go to a lot of lawyer seminars. I spent 2 years as co-vice chair of the Forensic Evidence Committee for National Association of Criminal Defense Lawyers. A whole lot of attorneys will withhold their opening statement until the state has closed its case. The reason being, they're used to defending criminals. The criminals they're used to defending habitually lie to everyone, their wives, their mothers, their victims, and the cops, and their lawyers. Okay, so they want to see what the other side's got. They don't want to make promises they can't keep. Only after the state is closed. Okay, now I know what BS I can put over on a jury and which BS I can't. And that means for this whole first part of the trial, except for where you guys have been able to poke holes in testimony and cross-examination, the jury's first strong impression is the other side's case. In a case like this, what I teach lawyers when I do CLE training for attorneys on how to handle this type of case is you give your opening statement where the name of it says right at the opening of trial. Okay, now whatever BS the other side's put up, from the beginning, the other side knows your side. Well, we're giving our case away. Listen, the other side gets discovery anyway, for heaven's sake.
Yeah.
Okay, the truth is on your side. The truth is what you're going to present. The truth is the strongest thing you've got. The truth ain't going to change. But get it in front of the jury now so they can compare it to the other side's theory of the case. And every witness they hear, they've got your side to compare it to. So you asked, what is the most controversial thing I teach? Probably that.
That's the most controversial. Yeah.
And we learned another lesson, never ask simple questions from garrulous old men who love the sound of their own voice.
Well, I love that as soon as you asked, Massad, you didn't have a hesitation. You already knew exactly what your answer was. You didn't have to give any thought.
Hey, everybody. Thanks for watching. I'm Michael from Gun Owners Radio. If you liked what you saw, please don't forget to like, subscribe, share, and make a comment. Help us out. Go to gunownersradio.com. Thanks for watching.